Good afternoon, and welcome to the City Club of Portland Friday Forum. I am John Horvick, President of City Club, and I'd like to welcome members and guests alike, those of you who join us today at the Governor Hotel, and those of you listening on OPB Radio or watching on Portland Community Media. Today, we will hear an analysis of how the decisions on the Defense of Marriage Act and Proposition 8 will affect couples here in Oregon. But first, some announcements. The generous support of City Club's corporate and media partners ensures we put on the state's best civic programs week after week. I'd like to thank our media partners, including Oregon Business Magazine, and our current Friday Forum corporate sponsors, Morel Inc., Northwest Natural, and Schwabe Williamson and Wyatt. We are grateful for your support and commitment to City Club's mission. Please join me in a warm round of applause for all of them. There will not be a forum next week, but we will come back on July 12th to hear the highlights from the 2013 legislative session with House Speaker Tina Kotek and House Republican leader Mike McLean. You can learn more about City Club events, purchase tickets, and become a member on our website, pdxcityclub.org. As always, City Club will be live tweeting this event. You can follow us or mention us at PDX City Club, and be sure to use the hashtag CityClub in your own tweets. We'll be having a Q&A session with our panelists at the end of today's program. Members, please come to the microphone to ask your question. And for all our audience participants, please locate the index cards on the center of your tables and write your questions on them during the Friday Forum. We'll collect them prior to the start of the Q&A. And now to our program. Today our panelists, David Fidanque, Jeana Frazzini, and Paul Gronke will discuss the implications that Friday's Supreme Court rulings on the Defense of Marriage Act and Proposition 8 will have on Oregon. David Fidanque began working for the ACLU of Oregon in 1982 as an associate director coordinating activities in Southwest Oregon, and since 1993 has served as its executive director. The ACLU of Oregon currently has 8 staff members, dozens of volunteer attorneys, and approximately 12,000 members. The executive director has primary responsibility for supervising the ACLU activities in its 4 major program areas, including litigation, lobbying, communications, and fieldwork. The Supreme Court case challenging the Defense of Marriage Act was filed by the ACLU, and the ACLU also filed friend of the court briefs at every stage of the Proposition 8 case. Jeana Frazzini is executive director of Basic Rights Oregon, which is committed to ensuring that all lesbian, gay, bisexual, and transgender Oregonians experience equality, and is currently leading the efforts to extend marriage rights to all through the Oregon United for Marriage Coalition. Before her current role, she was previously political director for the Death with Dignity National Center, and in 2009 was appointed to serve on the Oregon Council on Civil Rights. Under her leadership, Basic Rights Oregon has built a more inclusive movement, worked with coalition partners, and trained activists across the state to fight for social justice for all Oregonians. Paul Gronke is professor of political science at Reed College. He studies American politics and political theory with specialties in elections, electoral behavior, and public opinion. Paul is the founder and director of the Early Voting Information Center, where he and his team conduct research on early voting and election reform. He has published a book, The Electorate, The Campaign and the Vote, as well as articles in the American Journal of Political Science, the Journal of Politics, Public Opinion Quarterly, and many other prestigious journals. Paul is also a go-to source for local and statewide media outlets for his take on the political events of the day. And so without further ado, please help me welcome David Fidanque, Jeana Frazzini, and Paul Gronke.
So I'm Dave Fidanque, for those of you listening and watching on community television. I'm going to be talking a little bit about the legal implications of these 2 decisions by the U.S. Supreme Court today. But I want to start by doing something a little bit different, because what often gets lost when the U.S. Supreme Court hands down a landmark decision, and make no mistake about it, the decision in United States versus Windsor will be one for the history books and the law books for many, many decades to come. What gets lost is the personal story behind that case. And this is a love story between Edie Windsor and Thea Spire that started in the 1960s. They got engaged in 1967. Now that, of course, was a time when discrimination against lesbians and gays was not just taken for granted, but was institutionalized in our laws, in our businesses, and in every aspect of American life. So the challenges for a couple who wanted to be committed to each other for their lifetime were great back in the 1960s. Now think about it, 1967, that was 2 years before Stonewall. It was 6 years before the first gay rights bill was introduced in the Oregon legislature. We think of Oregon as being so progressive, but I should probably remind you that we weren't able to get protections against sexual orientation discrimination for another 34 years until 2007 in this state. So let me take you back to New York in the 1960s. Edie and Thea both had careers, they both worked, and they committed themselves to each other for the same reasons that any couple does. They were deeply in love, and they wanted to share that commitment with their family and friends. Had they been able to get married, they would have. Instead, they had to wait 40 more years before they could legally tie that knot. And then not in New York, but in Toronto, Canada. And you know, I'm a hopeless romantic. I admit it. This is the stuff of classic Hollywood love stories. And there actually is a movie about Edie and Thea's wedding, a documentary film that was made at the time called A Very Long Engagement. So in 2007, not only could they not get married in New York, but New York didn't recognize that marriage. But that came fairly quickly after. In 2008, the governor of New York issued an executive order recognizing Canadian marriages of same-sex couples. And, but by that time, Thea was gravely ill. She had been fighting multiple sclerosis for many years. And so that day was a joyous one for Edie and Thea, but it was also bittersweet that they'd had to wait so long. A year after that, 2009, Thea passed away. And you would think it would have been enough that Edie had to deal with that grief. But because of the Defense of Marriage Act, which had been approved by Congress in 1996 and signed by President Bill Clinton, the federal government came knocking and said, you owe us some money, $363,000 that Edie was required to pay in estate taxes because she had not married a man and because the Defense of Marriage Act treated Edie and Thea as if they were strangers. As grieved as Edie was, she was mad about that. And she went to see her lawyer, Roberta Kaplan, a partner at the Paul Weiss firm in New York City. And Roberta immediately called the ACLU, and that was the start of what became United States versus Windsor this week. The opinion is, I think, when you get to the constitutional issues, very easy reading, and I recommend it to all of you. Justice Kennedy wrote the majority opinion for 5 justices, the usual 5, if you follow the U.S. Supreme Court when a case breaks down on ideological grounds. But Justice Kennedy could have issued a narrow ruling based on principles of federalism and said nothing about equal protection under the law. And the Defense of Marriage Act still would have been thrown out, at least Section 3 of it, which was the part that said that the federal government cannot recognize any same-sex marriage under federal law. Instead, Justice Kennedy went well beyond that. And I think it's interesting to note that the person he quoted most often in this part of the opinion was himself, because he cited cases that in which he had written the majority opinion over the last 2 decades. First, the case that threw out Colorado's Amendment 2, which was similar to some of the anti-LGBT ballot measures put forward by the Oregon Citizens Alliance here in Oregon that thankfully we were able to defeat, but in Colorado, Amendment 2 had been approved. And Justice Kennedy had written the opinion for the then majority of the Supreme Court that threw out Amendment 2 on grounds of equal protection under the law. So he quoted from that opinion. And he also quoted from the opinion he wrote exactly 10 years earlier, to the day, Lawrence v. Texas, which had ruled unconstitutional the last remaining anti-sodomy laws, criminal statutes in the states that made it a crime for people of the same sex to engage in sexual conduct. But even then, Justice Kennedy went farther, because in his opinion, for the first time, is the recognition by the court that having 2 tiers of marriages and relationships is unconstitutional, and that it not only harms the individual members of that couple, but that it harms their families and the tens of thousands of children who have been raised in those families. Justice Scalia, there were several dissents, but Justice Scalia's dissent goes into the greatest detail about why the decision was a dangerous decision. Now remember that Justice Scalia had warned when the decision came down in Lawrence v. Texas, the sodomy case, that, mark my words, this will lead to gay marriage in the United States. And he said that again on Wednesday. But he went beyond that. I've never seen a dissent take language out of a majority opinion. He actually took 3 paragraphs, 3 excerpts from Justice Kennedy's decision, and he redlined them. He struck federal Defense of Marriage Act and inserted the state government and the state's refusal to recognize same-sex relationships, and showed specifically how these quotes could be used in the future to guarantee marriage equality for all lesbian and gay couples just a few years down the road. Now, this is one of those situations where we agree with Justice Scalia, and I can tell you today that I do think it is inevitable that the Supreme Court will issue that ruling. This was not the year to do it. And as you know, in Hollingsworth versus Perry, the Proposition 8 case, the court sidestepped the merits of the issues. They held that the proponents of Prop 8 did not have standing, could not go into court to appeal the trial court's decision. And so they kicked it back to the district court in California, the U.S. District Court. And what that means, of course, is that approximately 23 days from now, same-sex marriages will once again take place in California and will be required by a federal court decision. That is also a landmark. It's not going to be, I think the Perry case is not going to be the one that gets in the history books. It will be a footnote. But the impact of that decision, or that failure to decide, if you will, is huge. Because California will be the 14th jurisdiction, 13 states plus the District of Columbia, where marriage equality will be the law by the end of next month. And that means that 30% of all Americans, as of next month, will live in a jurisdiction where marriage equality is the law. Unfortunately, Oregon is not one of those states. As you know, we have a constitutional provision that was approved by voters in 2004, Measure 36, that prohibits same-sex marriages and prohibits the state or any subdivision, that is cities, counties, school districts, every other governmental entity, prohibits them from recognizing valid marriages from other jurisdictions. So for there to be marriage equality in Oregon, we have to amend our Constitution. And Jeana is going to be talking about that later. But what is the impact in the meantime of the Defense of Marriage Act being overturned for Oregonians? Well, the short answer is it's incredibly complicated, because there are more than 1,000 federal laws that mention marriage or make marriage a qualification for access to those programs, whether it's tax law or Social Security, you name it. Think of a federal program. Each of those may be treated differently. And under current federal regulations, many of those are treated differently. But in many cases, there is no direction to federal officials. Is it the place where the marriage was celebrated that determines the validity of the marriage, or the place where the individual applies for federal benefits? The answer is, it depends. And so if you are in one of those situations, you need to talk to a lawyer. And that ain't me. I'll stop there for now. Thanks.
I guess I'm up second. Are we ready? Well, thanks for having me. Thanks for inviting me today. Dave, it sounds like you guys have been doing some work. You can be doing some, yeah. So what I've been asked to talk to you today about is public opinion on gay marriage. What I'm going to focus on in the few minutes of time is on the change, because the story of public opinion about homosexuality, gay rights, and gay marriage is really a story of change. This is a change that, in my estimation, is about as rapid and dramatic as nearly anything we've witnessed in what is now 75 years of historical data on public opinion. So to help navigate this terrain, and I'm going to be brief, there's a lot of details here which I'm skipping over in the interest of having some questions from the audience. In order to navigate this terrain, we need some sort of GPS device. And luckily I have one for us. It's called the TARDIS, the Time and Relative Dimension in Space. That's just coincidentally that telephone time machine from Doctor Who. That just is completely coincidental. But I say that not just in joke, but to give you a couple tools to think about understanding public opinion. I am a professor after all, so I need to profess. And the thing to learn there is you want to try to avoid focusing on one question asked in one survey at one point in time. So what we're going to do is we're going to turn on the TARDIS. We're going to travel back in time. And we're going to go over what public opinion has looked like over the last quarter century, and then I'm going to tell you what I mean by space. But first, we're going to do the time dimension. So 25 years ago, it was a major achievement for gay rights when President Ronald Reagan first used the word AIDS in a speech in 1985. His own Surgeon General Koop's report on AIDS, and released a year later in 1986, was severely criticized by many political leaders at the time, including the Secretary of Education, William Bennett. So let's leave 1985 happily. Let's go forward 10 years. 10 years ago, almost, yeah, 10 years, 9 years ago, 13 states voted overwhelmingly to amend their constitutions to ban same-sex marriage. And exit polls showed that moral values, as asked in the polls, played a central role in re-electing President George Bush. A few years later, in August 2008, then-candidate Barack Obama said in an interview with Rick Warren, quote, "I believe that marriage is the union between a man and a woman. Now, for me as a Christian, it is also a sacred union. God's in the mix." The consensus of the political establishment in 2009, I think it is fair to say, was that civil unions were a viable solution to legal recognition and some of the health care benefits, but marriage was decades off. How things have changed. So looking at the time dimension today is a lot easier. There's websites like pollingreport.com, the Pew Center on the People and the Press, and Nate Silver's 538 column at the New York Times, which actually draws on the Pew data. All of these are readily accessible. The data are presented in a way now that use statistical tools to help you fly through that TARDIS. That is, to avoid looking at any particular observation, but to compare observations over time. If you've seen the 538, it's this line with the dots around it. It's essentially averaging a lot of different observations. And it's really the right way to do the work. It's really cutting-edge work. So in 2004, about 1/3 of the country said that they supported gay marriage. By 2011, the country was evenly split. In the most recent polls, most surveys are showing a bare majority. 51, 52% say they support, and between 40 and 45% opposing. These numbers may not be as high as you'd like if you're a supporter of same-sex marriage, but keep in mind how substantial the move has been and how rapidly it has occurred. I said before that this is a change about as dramatic as anything I've seen when looking at 75 years of public opinion data. I want to bring up one, I would argue, apt comparison, and that would be questions about racial relations in the US and particularly about intermarriage miscegenation laws. In 1961, any guesses how many Americans supported laws banning interracial marriage? 40% said they supported that law. So that is 60% supported laws. 40% said that we should get rid of these laws. 10 years later, in 1971, it was a bare majority who were saying that interracial marriage should be legalized. By the mid-1970s, we got to 60% support. By late 1990, it was over 80%. And by the way, you need to think about ceiling effects on some of these public opinion data. There's going to be hardcore groups of people for a lot of these items that will never say they support. The trajectory there is very much like gay marriage, and if it's going to follow the trajectory of intermarriage for blacks and whites, it will be 2040 until we get to 80% support levels. We're following about the same trajectory. So that's our travel over time. Now we're going to travel through space. What I mean by traveling through space is if you think about gay marriage from a public opinion perspective, you want to think about what are the other dimensions about homosexual attitudes toward homosexualities and gay rights that the public may be thinking about. And if we use the race comparison, there's three areas. One is general attitudes about moral and social practices. The second would be legal conditions. So in the case of race, this would be public accommodations, desegregation of schools. And last are a set of items about interpersonal relations. How often do you interact with individuals who are African American? Would you like your daughter to marry an African American? Would you have an African American over your home? Similar, so kind of interpersonal social relations. So let's start with the moral dimension, homosexuality as a practice. There have been questions asked since the early 1970s asking whether homosexuality is always wrong, somewhat, et cetera. 1973, 69% of Americans said that homosexuality was always wrong. That number declined to only 43% in 2010. That set of items about homosexuality as a practice that someone approves, I think, are very different than items about gay marriage, which in my view, and I think the view the data support, is really a question about legal treatment and about equality, and it's captured in Basic Rights Oregon's SMART campaign, that's about marriage equality. So it's not asking people to approve of particular lifestyles. It's simply saying, do you support equal recognition under the law for a practice which you may or may not approve of? That doesn't really matter. It's about equality. And I think most of us have seen the data on these figures. It's what I cited initially from a few minutes ago. It's just over 50%. And the data in Oregon are mixed, I guess I would say. It's not a slam dunk by any means. There was a survey conducted in late 2012 by the Public Policy Institute. First, Oregonians support voting on gay marriage like they do on everything. We vote on everything in Oregon. So the percent of Oregonians who said that voters should be making this decision was 77%. And at the time, the percent who said that same-sex marriage should be allowed was 54%. A more recent poll conducted by DHM Research for Fox 12 gave slightly lower numbers. This was conducted in April of 2013. The question was, do you favor or oppose changing the Oregon Constitution to allow same-sex marriage in this state? At that time, 49% said yes, and 42% said no, 9% expressed no opinion. The favor numbers were larger among individuals who reported voting less frequently, which is going to be a challenge for those who are out there working on this campaign. So Oregon, in that respect, is not that different from many other states. It's not a slam dunk in any means. The numbers are about balanced. And it's interesting to reflect back on what Dave said to start. So is this going to be decided in the courts through litigation? Is this going to be decided at the ballot box? And how those two different outcomes may play out in Oregon and in nationwide is, I guess, time will tell over the next 5 years.
Thank you. This is Jeana Frazzini. I'm the Executive Director with Basic Rights Oregon. And I'm going to wrap up our comments before we get into the question and answer. I think just speaking a little bit more about what these decisions mean for Oregon and what our path to the freedom to marry looks like here. So ultimately, I think as Dave described quite well, while the decisions out of the Supreme Court this week are monumental in terms of demonstrating literally the change of heart that is happening in this country and right here in our own state. The fact that in the now 14 states and the District of Columbia, where the marriages, the commitment, the love that is shared between gay and lesbian couples, couples of the same gender, is fully recognized, our federal government will now recognize that same commitment wholly. It's complex and complicated what it means for those of us in states that still withhold the freedom to marry from loving and committed couples of the same gender. And the work ahead of us is really about our own path. And Oregon's path, we have the constitutional amendment from 2004. We have attempts to remedy this situation in our courts, which have been rejected by the Oregon State Supreme Court. And we've worked for a number of years to build the conversation here and to build and create the opportunity to bring forward a ballot measure campaign, which now remains the quickest path to the freedom to marry in Oregon, and that's a vote of the people in November 2014. So I'm excited about the creation of a very broad and inclusive coalition of partners across this state, organizations and leaders, individuals, volunteers, who are coming together as Oregon United for Marriage to work on this campaign. It will require a great deal of our energy, a great deal of ourselves, because as much as the legal issues here are complex and oftentimes confusing, the emotions that are wrapped up in the ability of every loving and committed couple to care for the person they love, to take a stand in front of family and friends and make that promise to take care of each other in good times and bad, asking their family and friends to support them, is fundamentally at the core of these questions. And so we are excited to have the chance to have thousands of conversations with Oregonians as we collect the signatures to qualify this issue for the ballot. I'm actually excited to announce for one of the first times this week that we'll have petitions available on July 20th. Yes, there's It has been a long road to get to this day and to take this next step. It'll require 116,284 valid signatures to qualify for the ballot. That's at least 150,000 conversations that we get to have with Oregonians all across this state about the way in which extending the freedom to marry, ultimately writing the freedom to marry into our state constitution, truly reflects the values of who we are as a state. Oregon is a state that values fairness. We value freedom. We believe in treating others as we would want to be treated. And more Oregonians are coming to recognize that those values apply to the freedom to marry. So the work ahead of us in collecting those signatures is an opportunity in every corner, all 36 counties of this state, to engage in those conversations. We've been thrilled with the response of communities across the state. I was in Ashland, Oregon last weekend at a party at someone's home with over 120 people. When we did the February Valentine's Day launch on the petition, the initial sponsorship signatures on the petition in Astoria, Oregon, we had 9 people RSVP for an event. Over 100 showed up and just sort of bowled the organizers over. So with every opportunity, Oregon really is rising to the occasion on this issue. And these signatures are a key part of that. We'll be collecting those until the summer of 2014 when they're due. And that will, once those are submitted and certified, we will be on the ballot in November of 2014. So it's not an accident that the coalition is coming together under the umbrella of Oregon United for Marriage, because this will take all of us, and it truly is about uniting our communities, whether you're in the urban centers like Portland or Eugene, or you're out in Klamath Falls, out in eastern Oregon, in Pendleton, out on our coast. Wherever you are, this is about coming together and really thinking about who are we as a state. And who among us would want to be told that it's illegal to marry the person that you love? So I appreciate the opportunity to share what's next in that campaign and look forward to hearing your questions today. And with that, I'm going to turn it back over to John. Thank you.
Thank you all. It's been a monumental week, and we appreciate you taking time to speak to us about what these decisions mean for Oregon. And now, if you have a written question in your index card, please hold it up high so City Club staff can collect it from you. Our first question today is going to come from our Friday Forum host, Sharon Van Sickle-Robbins. Sharon's been a City Club member for more than 15 years and has served as our past president. Sharon?
Thank you. So, Dave, you mentioned that it's complicated. And I've heard a lot of people asking the question, if I got married in New York State and myself, my spouse, and my family moved to Utah, do those federal benefits follow with me to Utah? Is everything portable at this point in time? And could you talk a little bit more about how you think that's going to play out?
Sure. As I said earlier, it depends on the program. There are some questions that have simple answers. For example, if you're a member of the military, now that we've repealed Don't Ask, Don't Tell, if you're a lesbian or a gay couple, you can get married in one of those 13 states plus DC. And for purposes of the military, you will have a valid marriage no matter where you live. But in other programs, the answer will depend on what the regs say, what federal law says. And so, you're safest if you're, a lesbian or a gay couple, you're safest to live in a state where your marriage is legally recognized. And, as we've been talking about, that ain't Oregon, but it is Washington, and it will be California and, a number of other states. Over the coming months, President Obama has tasked Attorney General Eric Holder with leading a task force that will literally go through every federal program to review the current law, the current regulations, and to look at the actions that the administration can take to regularize the definition of marriage for the benefit of same-sex couples and marriage equality. There will be a lot that the administration can do unless Congress is able to step in and stop them, which I don't think any of us expect Congress to be able to do anything right now. They can't pass a budget. They can't do much of anything. We'll see if they can pass an immigration bill. So the Obama administration may be able to do quite a lot, but the state of the law as of today is very complicated. And on the ACLU website and on the website of a number of our allies are briefing papers on dozens of federal programs and what the impact of the Windsor decision is to those programs today, depending on what state you live in, what state you were married in, and the rest for lesbian and gay couples.
We'll now take questions from the floor. As always, we invite members to the microphone to ask their question. Asking questions at the Friday Forum microphone is a benefit of City Club membership, and membership is open to everyone. Before asking your question, identify yourself as a City Club member. Please ask only one question and ask your question as succinctly as possible. If I flash the question mark card, that means please wrap things up. Bill?
Bill Dickey, City Club member. At the risk of getting the question mark, I would like to say to everyone that we are looking for new members of the City Club, and if you're listening on the radio, you can go on the website and join City Club. City Club is a great thing to join. Please join us. My question, I guess, is to Dave. I would like to know if the federal government has ever banned any other kinds of marriages in the United States.
Besides same-sex marriages.
Correct, besides.
Prior to the Defense of Marriage Act, well, let me back up. There are many laws that, federal laws and practices that discriminated against LGBT Americans. All of those have been repealed, except for DOMA until this week. But when it comes to marriage, for purposes of the federal government, until 1996, a marriage was a marriage. If a state allowed that marriage to take place, the federal government recognized it. And I'll give you an example that will probably make your head shake. Think about what the minimum age to get married is. In some states, that age is very low. In Georgia, there is no minimum age for the female to get married as long as she is pregnant at the time of the wedding. She can be 12 years old, 13, 14 in Georgia. The federal government has always recognized those marriages. Here in Oregon, we would call it a felony.
Patty Farrell, City Club member. This question is for Jeana. Jeana, what do you think is the basis of the opposition that you will face in this campaign, and what are some of the arguments you'll be using to go against that opposition?
Sure. Well, there is strong opposition that remains, and we do anticipate that there will be strong voices on the other side of this issue here in Oregon. What we've seen in the most recent states that have had ballot measure and then legislative campaigns this year is that there's a lot of national leadership out of the National Organization for Marriage that will sort of parachute in and provide resources to counteract to be a part of the conversation, and so we fully anticipate that. Our focus is really at this point, and having built up to this point, is to bring Oregonians together as much as possible. And the initiative itself is titled the Freedom to Marry and Religious Protection Initiative, recognizing that often the types of opposition we face are based in deeply held religious beliefs. And we wanted to underscore the commitment and the reality legally that the freedom to marry and the freedom of religion can coexist. That what we're addressing through our state constitution is the rule of law and the promise of equal treatment under the law, which should extend to all loving and committed couples who are making that commitment to one another. And whether you're gay or straight, people really do seek to marry for this similar reasons, right? We fall in love, we want to build a life together, like Edie and Thea in the experience that Dave shared about the woman in the Windsor case. And we want to value the freedom of religion to determine what marriages they will and will not celebrate. And there's a growing voice of faith in this state and across this country for folks who do want to fully celebrate and recognize within religious traditions the commitment that gay and lesbian couples have made. We want there to be room for that, and we want there to be room for folks on the other side of that to be able to hold on to their own traditions. But changing the law fundamentally doesn't impact the ability of religious institutions and clergy to make those decisions within their own traditions.
Greg McPherson, City Club member. My question's for Dave Fidanque. In the majority opinion, Justice Kennedy relied primarily on the Fifth Amendment guarantee of liberty, that liberty shall not be abridged without due process of law, rather than the 14th Amendment's guarantee of equal protection under the laws. Two-part question. Were you surprised by that, and do you have a guess as to why it was based on largely on the Fifth Amendment rather than the 14th?
Well, thanks for that question. You know, as I understand it, the 14th Amendment is directed primarily at the actions of the states. And what I think the court has done in this case and in others is essentially to pull in the principles under the 14th Amendment Equal Protection Clause by way of the Fifth Amendment, which applies to the federal government in the first instance and through the 14th Amendment to all the states. So that's just a complicated way of saying, he cites the Fifth Amendment, but I think it's really an equal protection opinion. And it's through the Due Process Clause that you get to that equal protection argument.
Ted Kay, City Club member. Question for Dave. Once the ACLU got involved in the Windsor case, I assume you started paying for lawyers. Do you have any idea how much it cost the ACLU to participate in this case?
Well, I'm glad you asked. Actually, the ACLU generally does not, we don't hire outside counsel. So in this case, Roberta Kaplan, who was the lead attorney in the case, handled it, I believe, pro bono, without a fee. There may have been some sort of contingent fee arrangement, but I don't know the details of that. Occasionally, we will do that. Here in Oregon, if it's not a case we handle directly internally with staff, then our lawyers volunteer their time for us, and they never get paid for the work they do for ACLU. There were a number of staff attorneys who worked on the Windsor case, James Essex and Rose Sachs, who are staff attorneys with the National ACLU LGBT Project, and also attorneys with the New York Civil Liberties Union were very much involved.
This is fairly typical, actually. I was involved in a voting rights case last year. Usually large law firms will have pro bono budgets, I think, and that's probably the case here. And so the ACLU usually provides support, and but the funds are usually coming out of very large law firms, which, believe me, can afford it.
This next question comes from the floor. It's directed to Paul. Paul, they're curious about what sort of public opinion data you'll be looking for in the coming year, reading the tea leaves. What sort of opinions will you be looking for in the public to say which way that this election might go?
John, that question should go to you, shouldn't it?
But you're
Listen,
against today.
I think Jeannie spoke to this a little bit already. There's not a large evangelical segment in Oregon, and that the states where there's still high levels of opposition are generally located in the South or large evangelical communities. The Mormon Church has recently changed its, at least public position on homosexuality in a fairly significant way that may actually forecast some changes in Utah, which is kind of a don't ask, don't tell position on the position of the Mormon Church. So I guess, you know, if I'm looking at public opinion, it depends on I'm working, if I'm inside the tent or outside. Let's say I'm outside the tent, I'm trying to look at what Jeannie is doing with her campaign and other campaigns and trying to see whether, if I was working to oppose this, I would try to play on fears and change and make sure that I get older voters out where the opposition is, tends to be higher. If I'm looking at Jeannie's work, it's going to be more on equality and I think actually pragmatism. It's interesting, Jeannie didn't mention this, but I think the Oregon electorate is quite pragmatic and they don't want government messing around on all kinds of things. That causes us problems with our tax code, for example, but in this case, I think it's going to play to the advantage. Oregonians don't want government messing with them, and this is government messing with them in ways that they disapprove of. So I would look for that kind of attitudes. And how's the Democratic campaign? Democrats are much more supportive than Republicans. What's happening at the state level otherwise is going to increase turnout for one party or the other.
Alex Tinker, City Club member. Another question for you, Paul. You spoke to how public opinion sort of led up to this decision. How would you anticipate that the Supreme Court's ruling will impact public opinion moving forward?
So I hope Dave, I want Dave to chime in on this if you can. Boy, I don't know if I would say public opinion led up to this decision. I think the justices, the kind of, you know, John Grisham behind the scenes stuff we were seeing is that the justices struggled in balancing these two decisions, with not getting too much out in front of political movement, and some of the dissenting opinions stated, I think Scalia may have stated this maybe in the California case, that the political establishment was already moving. Therefore, the court itself does not want to get too far out ahead. This case, so one of my research assistants, Jacob Cantor of Reed College, is in the audience, and he pointed out to me that the Texas sodomy decision actually created a counter-reaction of public opinion opposing for a while, and the reason was that activist groups got mobilized. Roe v. Wade is a classic example, again, of activist groups getting mobilized. So I think there'll be coverage of this decision. A lot of it is going to be how is it viewed? Is it more of a loving couple and fairness in treatment, or are people successfully able to portray this in some ways as kind of a threat or undermining of the social fabric? So I don't know if I know the impact yet.
Well, I guess I would just point out that in the California case, there was not the usual breakdown between the justices. And in fact, Justice Ginsburg and Justice Kagan, normally part of the so-called liberal wing, although I think they're very moderate, and Justice Breyer also were in the majority in not recognizing standing in that case. It's important to understand that Justice Ginsburg, before she became a judge, was critical of the Roe v. Wade decision, not because of the outcome. She started the ACLU. She was the first director of the ACLU Women's Rights Project. She's a strong proponent of reproductive freedom. But she felt that the Supreme Court moved too soon on the abortion issue, that the court foreclosed the conversation, the dialogue in the states, the political process. And so I think the court is very aware of public opinion. And in the sodomy case, there were only 13 states left that made criminal sexual acts between consenting adults of the same gender at that time. Now, are we going to have to wait for the Supreme Court to issue a broad marriage equality decision until there are only 13 states left? I don't know. That's a pretty high bar because there are so many that have provisions in their state constitutions now banning recognition of same-sex marriages. but I don't think there's any question the court is very much looking at public opinion. I believe very strongly that we will see a bump in public opinion in support of marriage equality. That may fluctuate back and forth over the coming months. But I think, Jeana, maybe you want to talk about a little bit more about the nature of the conversations that we've been having with people around the state and how people are torn and what it is that's important to them.
Right. Well, and I did want to speak to this question of how the court's decision may impact public opinion, because I think in my non-scientific view, what we have seen is that every time there's an extension of equality where the recognition for relationships as marriage, where barriers to employment are broken down with the fall of Don't Ask, Don't Tell, every time gay, lesbian, bisexual, and transgender Americans are one step closer to the freedom that our country promises, it opens up the opportunity to be truly who we are and to engage in heart-to-heart conversations with the people in our lives about our hopes and our dreams and our struggles and our challenges, and it brings us closer as human beings. And that is ultimately what has, I believe, stood in the way of addressing the issues, many of the issues that we face as a community. To think that in 2004, when our Constitution was amended to restrict marriage and exclude loving and committed same-sex couples, at that time it was still legal in most of this state to be fired for being gay, lesbian, bisexual, or transgender. So you had an electorate making a decision on this question who didn't even have the opportunity to truly know who was sitting at the desk next to them at work. If you can't bring a photo of your family or have an honest conversation about your weekend plans with the person next to you, then you certainly can't find that common ground and that common humanity that I think is necessary to make the critical changes in our law, whether we're talking about marriage equality, whether we're talking about barriers that separate us along race, along economics, along so many of the issues that we still continue to struggle with in this country. And so I think that absolutely the pace of change on these issues is deeply connected to every step forward that we take in legal equality opens the door for folks to have those heart-to-heart conversations and to engage in a way that isn't about I'm on one end of the political spectrum and you're on the other, but is really about finding that spot in the middle where we're really human and we are able to connect on what that means. Humanity is about connection. It's about caring for one another. It's about feeling as though your life means something that's bigger than just who you are. And so I believe truly that the opportunity in front of us in Oregon is to become that much more connected to our humanity and to who we are, and in doing so ensure that whether you're gay or straight, you have the opportunity to make that lifetime commitment to care for that special someone and to have the community embracing you in doing so.
Paddy Tillett, City Club member. David, you mentioned that the definition of marriage may affect 1,000 or more other laws. I wonder if you could enlarge on what some of those are and what other ripples we can expect as a consequence of the finding.
Do you mean in terms of the impact of the defense of marriage decision, or?
No, the impact of that definition on other laws which make reference to marriage.
Well, it means the difference between whether you're in or out, whether you're excluded or included. And it's often, well, and let me back away from that because I think,
Can I just say, I
yeah.
think what he means are things like, if I'm correct here, you mean things like in the welfare code. Like if you qualify for benefits under welfare, the question is your spouse and Social Security, survivor benefit. I think what he means is like what, give us a sense of the kind of range. You say thousands, that sounds like a lot. Why is it so big?
Well, Social Security is a great example. You know, if you're a straight couple that's been married for 18 months and one member of that couple had worked for 50 years and passes away, the spouse is entitled to receive the Social Security benefits of the larger wage earner, even if they've only been married for a short amount of time. But if you're a same-sex couple like Edie Windsor and Thea Spire, who were together for 44 years, when Thea died, Edie didn't get Thea's benefits. It was as if they were complete strangers under federal law. So the question is now, with Social Security and with all of the other programs, if that marriage is recognized where the marriage took place, should those benefits cross just the way it would for any straight couple? We think the answer should be yes, but whether it will be yes depends on the program. But there's one other thing I wanted to say, and I know we're almost out of time, which is that when we had the campaign in 2004, afterwards, in research, we asked voters, why do straight couples get married? Well, they get married because they're in love and they want to commit themselves to each other for the rest of their lives. And we asked them, why do gay and lesbian couples want to get married? Because they want the benefits. And many voters in the middle thought it was about the benefits. It's not about the benefits. That's important, and the impact on people's real lives can be dramatic. But it's really about just being treated the same under the law as your neighbor and the other members of your family. And that's basic. It's about love and commitment.
Dave, I think this question's probably for you too, and it's what about full faith and credit? If a couple gets married in Washington and moves to Oregon, then notwithstanding Measure 36, notwithstanding the other parts of DOMA, why isn't Oregon required to give full faith and credit to that marriage, and is that lawsuit in the works?
I'm not an expert on full faith and credit, Corey, but my understanding is that Measure 36 and the other parts of DOMA would kick in at that point because those are still in place.
But full faith and credit is a constitutional provision. Why doesn't it overcome those?
The smart lawyers I've been talking to tell me that's not likely to be a winning argument.
Right. Think about the Supreme Court as a coalition, and you had to bring Kennedy. The question was asked earlier about why the Fifth Amendment, not the 14th. Well, you got to think about Kennedy, right? How are you going to get Kennedy in on the coalition? How can you build a winning coalition? And I don't think they're ready for full faith and credit yet. They're not ready to essentially override all of the state laws.
They're trying to give more power to the states, not less, the individual states. So I think the federalism issue will override the federal government being able to dictate through the Constitution.
One more question from the floor. We have to get a quick answer, and that has to do with immigration and the effect that these court cases might have on binational couples.
As we understand it, same-sex couples now will be able to apply for a green card for their non-citizen spouse, the U.S. citizen member of that couple, assuming they live in a state where the marriage was valid, but it was DOMA that prevented that, and that part of DOMA is now gone.
Jeannie or Dave, I saw a count, I thought, in the tens of thousands, right? I think that's the number of couples we're talking about here. I mean, this is going to affect a tremendous number of people.
And one of them is Glenn Greenwald, who's the reporter that's broken the Edward Snowden NSA stories in the past week, in the past few weeks, who is together with his partner is a Brazilian citizen and has been barred from immigrating to the U.S. because of DOMA.
Well, we've run out of broadcast time for further questions, and we'll have to stop for the day. Please join us on July 12th for a legislative wrap-up with House Speaker Tina Kotek and House Republican Leader Mike McLean. And as we close for today, please join me in offering our sincere thanks to David Fidanque, Jeana Frazzini, and Paul Gronke.